for this UNT HR Collaborative webinar, since we've been transitioned to this for the last year now. So we wish, of course, that we could gather together in person over lunch, free food or cheap food that tastes delicious, thanks to our sponsors and donors like John Kelly and Jennifer Kelly. And we're excited to provide this webinar to you all today, hopeful that we can, in the fall, begin to start incorporating some of those face-to-face events once again. Slide, please. So I just wanted to provide a little bit of an overview of what we have coming up this coming year. So we've obviously already had one event, so thank you all who have been to all of the events now, all two, that we've had this year. Today, of course, we're going to be having a discussion on COVID workforce reintegration. Being proactive is key. Obviously, this is something that is kind of top of mind awareness for many of us as we try and figure out how we're going to go back to work, what that's going to look like, and the best way to do it. And so our guest speaker today, Leiza, is going to be talking to us about that, giving you guys some great information. We also have our speaker lined up for September 9th. We do not have a topic set. He has a couple of areas of expertise, so we're kind of gauging what might be the most valuable to you all. Dr. Mahid Yagi will be speaking. That's going to be a virtual event just because we're not 100% sure what September is going to look like yet. For those of you in the audience who are HR alumni from UNT, we will be doing, hopefully, our celebrated annual alumni dinner. This past year, we were supposed to have a big bash. It was the 5th year that we had been doing it. Obviously, we had to cancel that because of COVID. So we're hoping to really have a great turnout for that this year. So more about that as we continue on with our planning. And then on November 4th, we are planning an HR executive networking event. So our tentative plan is to have that face-to-face, hopefully at a nice restaurant where we can have our HR executive audience networking with one another. If you have people who are possibly interested in your organization, please pass that along to them, and we will make sure that we are communicating more specific plans as we move forward. Before we get started a little bit more, I have a couple of other things that I wanted to bring up. First of all, the Q&A at the end. So you can see our agenda today. Our keynote speaker is Leiza Dolghih, and she's going to be talking, as I mentioned, about kind of reintegrating people into the workforce, as we kind of move into this new post-COVID world. She is a labor and employment partner with Lewis Brisbois. And then we're going to have, after she has done her presentation, we're going to open it up to question and answer session. If you would, kind of like what we've done in the past, I know some of you have submitted some questions before the session. If you have any questions that come up during the session, as we've done the last couple of these, please put them in the chat, and Tabitha, our amazing moderator, will be selecting those questions as time allows at the end of the Q&A session. So I also want to put in a plug for all of us at UNT who are faculty and doctoral students. We have ongoing research opportunities for you all. We're happy to partner with your organizations to address any problems that you may be experiencing, whether they're COVID related or not, identify trends and provide solutions to you to help you kind of navigate your day-to-day concerns. I know a lot of people use consulting organizations and things like that. One of the things that you have with us is that we're typically pretty inexpensive or free. Our doctoral students need data, our faculty need data, you need problem solved. It's a great partnership. So if you're interested in that, we have a great faculty. We're made up of experts in employee retention, improving work and non-work domains, employee identity, diversity and inclusion issues, team learning, support for employees. There are a lot of other areas that we have faculty that are specialized in. So please reach out to us. Again, we're pretty cheap. Most often we're free. So if you're interested, you can reach out to Kathy, you can reach out to me, or you can visit our website at cob.unt.edu/HR. And we'll be happy to listen to you, figure out your situation, learn more about you and your organization, and work with you to curate a customized approach to fit your needs. So one such research opportunity is actually something that I am currently working on. So I'll share the link in the chat. Some of my co-authors from Mississippi State and the University of Delaware and I are looking at leader experiences and attributes in organizations. And so this study consists of 4 short 5-minute surveys, and it's going to be done over the next 10 weeks. So we're going to be providing $10 Amazon gift cards for anyone that would take 15 to 20 minutes of their time over the next 10 weeks to complete all 4 of those surveys. I'll put a link in the chat if you're interested. In order to participate, you have to supervise at least 2 employees. If you don't qualify to participate, but you know someone who does or might be interested, please feel free to share that link with them. We'll be closing that on Monday, so be sure to share it soon, I guess. And finally, we have some really exciting news that we're going to be announcing in the coming months. We're in the process of expanding our HR program here at UNT. We're going to be focusing a lot on enhancing our involvement and visibility in HR organizations. We're going to be working with SHRM and HRCI through recertification credits as a preferred provider. So those are going to be opportunities that are going to be occurring in our upcoming events. And then, of course, annual conferences and some of the HR professional development workshops that we're going to be providing in terms of SHRM and HRCI exam preparation. So those are just a few of the things that we're going to be offering as we move forward. Again, we're going to have some more exciting announcements about that as the summer progresses, so be on the lookout for that. And I think that pretty much takes care of business for today. So without further ado, I'm excited to now introduce our keynote speaker, Leiza Dolghih. She is a magna cum laude alum from UNT with a bachelor's in business administration in HR management. She's a very proud alum, and she is also a JD law degree holder from Baylor. She graduated in 2006 and has been selected to several prominent lists for best lawyers under 40 list from 2018 to 2021, best lawyers in Dallas list from 2017, 2019, and 2020 by D Magazine. Also, she has been selected as one of Dallas's top 50 women lawyers in 2018 and as a rising star in 2017 through 2021 by Texas Lawyer. She's board certified in labor and employment law and a public speaker on employment, not environment, I can't read my own writing, law issues. And you can check out her writings at her blog, www.northtexaslegalnews.com. So without further ado, Leiza, please take it away.
Thank you so much for such a generous introduction. And Julie and Tabitha, I'm going to share a screen from my computer because I don't think I can drive slides from Tabitha's computer. Or if there's a way to do that, I haven't found a way to do it. So let me really quickly pull up the presentation. Can you see it on your screen? I think you're all muted. Can someone confirm that you can see the slides?
Yes, we can.
All right, excellent. Okay, so lots of information to cover. I feel like last year we were all dealing with going home, being kicked out of our offices, and COVID was just starting, and now we're entering in phase 2 where we're asked to return back to the office. And there's a whole slew of issues that's connected to that transition. I expect that there are probably a lot of employees that have gotten used to working from home and maybe not looking forward to that transition. And that's something that the employers are going to have to deal with. So today we're going to talk really quickly about just general COVID-19 litigation trends in the employment law. I get a lot of questions from HR professionals, what's going on out there? Are employees really suing for COVID-related issues, or is this just kind of a hype issue in the newspapers? And I will share some statistics with you. And there's definitely, there's a segment of employees that are definitely using COVID as a way to generate more litigation in various ways. We're going to talk about just generally issues that arise when employers require employees to return to the office, what employers should anticipate they're going to have to deal with. I mean, 100% of employers are going to have to deal with those issues if they're trying to get their employees back in the office. We're going to talk about some of the frequently asked questions about, what if an employee doesn't want to come back to the office? What if an employee says, they are scared of COVID and things like that? What safety measures employers should be taking before they require their employees to come back to the office? Can employers require employees to get tested before they come back to the office? How often? Can they require employees to get vaccinated, right? Really hot issue. And then we're going to talk about some of the things that employers should be doing in anticipation that some employees may just quit instead of coming back to the office. And, just kind of general, guidance or advice on how to avoid some of that litigation. So a lot of information to cover. I'm going to go through it very quickly. If you have any questions, please put it in the chat box, and we'll have a Q&A session at the end, and we'll try to answer as many questions as I can at the end of the presentation. So let's look at the kind of general trends in the employment litigation as it relates to COVID. So I entered a search in a Google box yesterday. I typed, "Can I sue employer?" and let the Google fill in, the rest. And as you can see, the very first topic that Google suggested for me is, "Can I sue employer for COVID?" or "for firing me" is the second, kind of most Googled category. So it's definitely on employers' mind. The rules in the employment are changing. A lot of people have been laid off. A lot of people's salaries have been reduced, and employees are looking for ways to kind of recoup some of the financial burden that they've had to undertake related to the employer's decisions. And litigation is definitely on their minds. So this is stats from last year, compiled by Littler Mandelson. And they're tracking lawsuits that are being filed around the country where employees are alleging some sort of employment-related claim, and also the claim relates to the COVID practices or some other COVID-related issue. And you will see there's a definite rise from March of last year when the pandemic sort of officially started in the US, and the cases have been on the rise through the end of 2020, and they're still continuing to be filed in 2021. Some of them are class actions. And so actually the new type of class action that we're seeing is employers suing companies for not paying them for the time that they spend undergoing safety procedures. So those 5 or 10 minutes before work where they have to, get their temperature tested or get, their workstation disinfected, if the employers are not paying them for that, we have seen it's a new kind of claim related to COVID in that area. And so there are a lot of novel kind of claims that are being tested in courts right now on a variety of employment issues. So we expect that to continue. So most common claims when it comes to COVID-related litigation is the retaliation claim. And I'll talk in the next slide a little bit more about that. But you will see that on the slide, it far exceeds the rest of the sort of types of lawsuits. Wrongful termination, always a popular cause of action. Discrimination based on disability, that's going to come into play when vaccination and testing become mandatory. You will see a lot of employees claiming that they should not be tested or should not be vaccinated due to a disability that they have. You see FMLA claims related to leave. You see workplace safety issues, people especially back in 2020, reporting that my employer is not following safety procedures that are recommended by the CDC, or they're not keeping me safe in the workplace. And then the rest kind of the claims, span a wide gamut of employment actions. But why I kind of start out my presentation with this is a lot of those claims can be eliminated if employers are proactive. So I know last year, a lot of companies were dealing with this in a very fast-paced environment. There was not a whole lot of guidance. We didn't know much about the disease. There were no regulations or laws in place. Everyone was kind of relying on CDC, but CDC was also taking its time to figure out what's going on scientifically before they could issue guidances. So there was really not much choice. Everyone was kind of flying by the seat of their pants, But this time around, transitioning employees back to the office, we actually have a whole lot of guidance. And we're going to talk more about that. And we have a lot more time to prepare for that transition. So I would suggest that a lot of lawsuits can be avoided, of this type of lawsuits can be avoided if employers take their time and plan the transition and think through about the issues that are going to come up when that happens, because those issues will come up. So I want to bring up the retaliation claim because a lot of times I think employers don't underestimate or don't understand how this claim works. So you have employees, complaining about discrimination. Everyone gets that. You're not supposed to discriminate against an employee because of a disability, for example, right? An employee comes in and says, I can't get vaccinated because I'm allergic. So, but I still want to come to work. So, how are you going to accommodate me? Most of the employers hopefully understand that they can't discriminate against the disabled employee, but where a lot of times the ball is dropped is the retaliation end of it. So even if an employer accommodates an employee like that and gives them some sort of a special reasonable accommodation, then you have a supervisor who is pissed because this employee went over their head or went to HR and asked for an accommodation, and the supervisor starts retaliating. And so a lot of times employees will lose the actual discrimination claim. The court will find, hey, the employer did everything right in terms of accommodating your disability, but they win a retaliation claim because they were either fired or demoted or subjected to some conditions from their supervisor or somebody who is overseeing them as a retaliation for them asking for an accommodation. So I think employers need to always think about the retaliation, train their managers on retaliation, that it's not allowed, and kind of make sure that the retaliation doesn't come to bite them at the end. And those claims are on the rise for many reasons. As people get laid off, again, they're looking for ways to recoup the financial losses that they've suffered. And one of those ways is litigation in the US. So let's talk specifically about, can an employer require employees to return to the office? I mean, the answer generally is yes, right? And that's why you're reading all these articles about different companies coming up with different plans. Some are going to require their employees to come back in phases or have already started doing so. Others are going to enter in a permanent arrangement where a lot of the employees are going to be allowed to work from home part-time, let's say 2 days, and then spend the rest of the time in the office. So there's a variety of plans that an employer can implement. It really depends on what their business model is and what makes sense for them economically. But generally speaking, can an employer require employees to come back to the office? Yes. But there's a big, kind of exception to that is employees that require a disability accommodation. And we'll talk about that in a second. So just generally speaking, what are some of the excuses that employees are going to give, right? That they don't want to come back to the office. And judging, I live in a big apartment building, and I have met most of my neighbors. A lot of them are working from home, and just from chatting with people, different ages, different professions, different companies, most of them are enjoying working from home. And I don't think really are looking forward to coming back to the office. So is an excuse, I'm scared of catching COVID. I feel much safer in my apartment. Is that a legal excuse? No. I mean, that's not a good enough reason. If that's an employee's excuse and they refuse to come to the office because they're scared of COVID, then they can be terminated, obviously. I work better from home, right? Some people do, some people don't. Again, not a legal excuse, but you can definitely foresee some employees arguing that. You're going to hear a lot from employees about childcare options. Obviously, it was a big issue last year, still is a big issue. And then was I muted?
It just happened just for like 2 seconds. You're okay.
Weird. Okay. Well, the only reason that an employer really, needs to consider is whether an employee has a medical condition, a disability that would require an employer to provide them with a reasonable accommodation, which means not require them to come into the office while they're requiring the rest of the workforce to do that. There's nothing special about COVID itself that makes it a disability. You have to treat any requests for deviation from the policies as just any other ADA, Americans with Disabilities Act request for accommodation. So, and once you determine that an employee does have a disability, engage in an interactive process to figure out, is there anything an employer can do that would help the employee do their job, but also kind of deviate from the policy that the employer has for the rest of the employees. All right, so just a quick ADA refresher. It applies to all the companies that have 15 or more employees. A disability is a legal term under the statute. It's not a medical condition, so it involves a lot more than what you would typically think as a disability, you know, in a common use of that word. A disability under the Act is a physical or mental impairment that substantially limits a major life activity, such as, you know, hearing, seeing, etc., and working. So it can include mental health conditions, such as anxiety disorders, depression, obsessive compulsive disorders, post-traumatic stress disorders. So all of those kind of conditions that employees have, and this goes beyond just I'm scared or I'm comfortable, I don't like it, you know, being in the office because I might catch COVID. We're not talking about just excuses. We're talking about documented medical history of somebody having a disorder, a mental health disorder that makes them so anxious to be in the office that they can't really perform their job. In a case where there is a disability like that, the employer must provide a reasonable accommodation. Okay, you don't have to go buy somebody the most expensive $10,000 chair to accommodate their disability. But if it's a $500 chair, yes, that would be a reasonable accommodation, unless there's undue hardship. So if a surgeon says, I can't come into work because, you know, I have anxiety about COVID, well, they can't perform their essential job functions, surgery from home. So they're out at that point. If they can't perform their job, you don't have to keep them on the payroll. And the important thing to remember, which I think a lot of employees don't realize, is that the employer may choose among different reasonable accommodations. So a lot of times where we see litigation arise is where you have a difficult employee who comes in and says, I need this particular accommodation. The employer looks at the accommodation and says, you know what, this is too expensive, it's not reasonable, it doesn't allow you to perform your essential job duties. You know, a whole variety of reasons why the particular requested accommodation by the employee is not going to work, and the employee thinks they can dictate that's the only accommodation I will accept. Well, that's not true. If an employer offers a reasonable accommodation and the employee rejects it just because they don't like it, they're out. An employer doesn't have to do any more than what they've already done. I put a link here. There's a website. It's called askjan.org. Job Accommodation Network is what it stands for. And if you're looking for examples or you're wondering how employers accommodated this particular disability or how they have done that, you can actually, there's a wide variety of resources on that website. And you can actually Google the library of resources and see if a particular disability has ever come up. For example, I, a while back did not know that someone's inability to tolerate certain smell can be a disability, but it can be. And so you can go on that website, and if you're wondering, you have an employee that has that disability or claims that disability, you can go and see how other employers have accommodated them. So really great resource, and if you want to write it down and check it out, it would be a good resource for you, especially as COVID issue starts arising. So handling employees that have higher risk of COVID-19, right? Older employees with medical conditions. First of all, if they refuse to come to the office or they ask for any deviation from any of the COVID policies, right? If an employer requires everyone to wear masks in the office and somebody says, I don't want to, employers should find out why. If it sounds like, are they asking for an accommodation request? Are they saying they're allergic to this particular mask that the employer is providing? Well, maybe providing them with a different mask might be an easy solution. It definitely would be a reasonable accommodation. But question number one is, are they actually requesting an accommodation? And an employer can ask an employee medical questions or request documentation when the need for accommodation is not obvious or already known. If somebody says I have anxiety about COVID-19, and they've been going to every Friday to a happy hour to the busiest bar near your office, mingling with people without masks and having a good time. Well, question, I think you can ask for medical records saying, hold on, we need a doctor's note here saying you have that, and then in that situation that might not even work, if it's obvious that they're sort of faking the request. Employers should check CDC safety guidelines for different safety options. So CDC gives a whole list of measures that an employer can undertake, at their workplace. Some employers implement all of them. Some employers implement some of them. Some employers implement certain measures in one part of the office, but other measures in the warehouse. So, but you have a variety of things that you can consider. So if an employee works in an office and they say, I don't want to come back to the office because I have a disposition or some medical condition that would make me get COVID, would make me more prone to get COVID or have more serious complications from COVID than the rest of the people, then maybe you can consider, whether you need to put plexiglass around that employee, whether you need to make sure that other employees, when they talk to that employee, stand 6 feet away, which they're supposed to be doing anyway, but maybe there's an extra measure that you can undertake. So CDC safety guidelines is a great place to look for different accommodation options. Some employers are willing to excuse essential job functions. So if somebody comes in and says, I need to keep working from home because of a medical condition that makes me more likely to catch COVID, and they can only do, 2 out of 3 duties from home, then maybe an employer can consider, do they really need to be doing the 3rd duty? And maybe the answer is yes, they need. It's an essential job duty, and so there's really no accommodation that can be made for that. An excuse of essential job duties can be temporary. So just because an employer says, okay, for now you don't have to do this, it doesn't mean that they can't later come back and say, okay, that was for 3 months and now we're going back to where you need to be doing this. And if the employee can't do it at that time, then they're out. And employers can grant accommodations on trial basis. So it doesn't have to be forever and ever. Once you let somebody work from home, doesn't mean they can work from home forever. And can provide different accommodations. So this is going to come up with some employees who at the beginning of the pandemic said, I have this medical condition, I can't work from the office because I'm a high risk employee. Well, now when employers are going to start recalling their employees back, this employees might say, hold on, I've been working from home this entire time, I would like to continue this accommodation. Employers are fully within their rights to say that was a temporary accommodation. So we're going to look again now. The situation has changed. It's been a year. People are getting vaccinated. So we're going to reassess it. And if it looks like that accommodation is no longer reasonable, employers may provide something else. So they're not boxed in. I think the important part with dealing with these types of situations is, first of all, engaging in the interactive process. Because really, if you do end up in a lawsuit, what the jury wants to see is that the employer really tried to accommodate the employee, that they had this conversation saying, how can we help? What do you need? And you want to look like the good guy as the employer in that process. And the second part is documenting the efforts, documenting the fact that the accommodation is only temporary, or that it's an on trial basis. So those are 2 key things in going through that process. The questions to ask every time is, what accommodation is the employee requesting? Why is it being requested? Who's requesting accommodation? Where is the accommodation needed? When will the accommodation begin and end? And how will the accommodation solve the issue of performing the essential job duties, meeting performance standards? I think that should be a checklist every time that an accommodation request is being made. So as people are, being transitioned back into the office and are saying, I can't come in because of a medical condition, that's the list that the employer should go through every time. Here are some of the commonly requested COVID-19 related, adjustments. Telework, obviously, a lot of people have been doing this. I'm doing it right now. Equipment to telework, job restructuring, personal protective equipment, policy modifications, so either masks or vaccinations, schedule modifications, right? A lot of employers have begun doing staggered shifts or staggered days at work, where only 1/3 of employees, for example, comes in on Monday through Tuesday, and so on. People rotate, or they're doing hot desks. And then leave is also another accommodation available. So if an employee says, I can't come in because I have a medical condition, and the employer says, well, you can't work from home because you can't perform your essential duties from there. Leave, unpaid leave, obviously, is an approved accommodation. So EEOC has said that's an appropriate accommodation in that situation. Okay, some of the frequently asked questions that employees and employers wonder about. And this is from by the way, from the EEOC website, their most recent guidance. May an employer request information from returning employees about their health? Yes. So if you want somebody to fill out a form every day or every week confirming they don't have symptoms, that is perfectly acceptable in that regard. You can ask them questions. Do you have the symptoms, or have you been tested for COVID, and receive positive results? May an employer take the body temperature of employees? Yes, as well. So because I have my blog, I get a lot of random emails from people that are reading and just fire off questions at me. I rarely answer them unless they're serious questions, but I have gotten a lot of random emails from employees out there saying, an employer's taking my temperature. They can't do that, can they? Or the second question about temperatures, can they actually record the actual temperature I had, or can they only keep, pass fail type of information? Well, the answer is they can record the temperature, and they can record, they can take the temperature and they can record it. Obviously, that information needs to be kept confidential. And if it gets in the wrong hands, an employer will be in trouble, which is why a lot of employers choose to just do pass fail as opposed to recording somebody's exact temperature. But they can certainly do that. May an employer, excuse me, may an employer require returning employees to self-report about their health? Yes, again, employers can ask that information because they need to protect the remaining employees. And so they need to figure out if an employee that's coming back to work has any symptoms that could put other employees in danger. May an employer ask only one employee questions designed to determine if she or he has COVID-19, or require that this employee alone have her or his temperature taken or undergo other screening or testing? Again, the answer is yes. So if the employer has a reasonable belief based on objective evidence that this person might have COVID, they can actually single out the particular employee and say, you need to get tested, and ask them questions about symptoms. A situation like that may be, if you have two people working in a cubicle and one of them just reported that they had COVID, it's reasonable for the employer to say, look, you sat next to this guy yesterday. We need to know if we need you to get tested, especially now that testing is available pretty easily. May an employer require returning employees to provide a note from a doctor or other healthcare provider certifying fitness for duty? Yes, again, consistent with the other ADA guidelines on, not related to COVID. May an employer ask returning employees whether they have been in close contact with anyone who has been diagnosed with COVID-19 or is experiencing symptoms associated with COVID-19? Yes. Again, that's part of those kind of questions that employer can ask employees to make sure that they're not bringing virus to work. There's a kind of a parallel question to that, where, can an employer ask, have any of your family members had COVID? And that is a no-no. So it should be just a broad question, not limited to family members. So great. Okay, we can bring employees back to work. We can ask them a bunch of questions. We can get them, require them to test. Now, what do we need to be doing in our actual workplace to make sure that, we're not in trouble? Well, first of all, I think, employers should realize there's no federal regulation or law that requires certain things in the workplace. So if you're not doing anything, I mean, technically you can't be fined by the government. obviously you should be doing a lot of things, but those are guidances from the CDC and OSHA. So if you have been kind of piecemeal implementing some safety measures or others, right, kind of moving very quickly from the last year, now would be a good time to go to the CDC website and go to the OSHA website and go through the checklists that they provide of safety measures and see, you know, do you need to add anything to your measures that you're already implementing. You know, earlier this year in January, President Biden issued kind of an order saying that OSHA should come up with an emergency standard, which would make it mandatory for all the employers as to what they have to do. And it would be like a lot of other things that OSHA requires in terms of safety. Employers would have to come up with a plan. You know, they would have to, OSHA would enforce compliance. They'd come in the facility, audit the employer's compliance, fine the employer, but it's looking less and less likely that OSHA will pass anything like this because of the timeline and the timeline of vaccination. So I don't think it's very likely that we're going to see a federal universal safety standard for COVID-19 this year, unless an emergency happens. And I say that because, you know, we're hearing this articles or seeing these articles about new strains and how they're more, how they're spreading faster, how they have, you know, worse consequences for younger people. So I don't know what the future holds, but so far it's not looking like it's likely, because for OSHA to pass a federal standard that would apply to every employer in the country, even employers with one employee, OSHA would have to show that there's grave danger to the workers. And as more and more workers are getting vaccinated, that standard is not likely to be met. Since 1970, OSHA actually enacted only 9 emergency safety standards. 6 were contested in court and 4 were stayed by the courts. So out of 9 that they tried to enact, only 5 actually went into effect. And so now that we have 33% of people in the country that have received at least 1 shot of the vaccine, I think given how long it takes OSHA to actually publish and then wait 6 months for comments and then make the rule final, I mean, it's not likely to happen this year. However, I think employers need to remember that even without any COVID specific rules, they have a general duty requirement under OSHA, which is verbatim from the statute, is each employer shall furnish to each of his employees employment in a place of employment which are free from recognized hazards. And COVID-19 is now considered one of them. So, you know, employers do need to follow OSHA and CDC guidances to make sure that they're meeting that general safety duty. All right, so I'm not going to go in detail. I'm just giving you some examples here. You know, assign a workplace coordinator at work, do a COVID-19 hazard assessment. I would encourage you, if you're wondering, like, am I complying with this? If you're not 100% sure, go to the website and take a look at OSHA website, or just Google it. It will come up, OSHA guidance for COVID-19, and just go through that checklist and see, is there anything else I need to be doing before we open up the office and make everyone come back? And they have 2 kind of lists, you know, and one of the first things they say, obviously, if you're sick, go home. So barriers, PPE, all of the stuff that a lot of companies have already been doing. Employers need to be aware that they have recording requirements. So if they think there is a COVID-19 case that's related to workplace, they need to reasonably investigate it and figure out if it's work-related or not, and then report it to OSHA. I included it here on how OSHA tells employers whether it's work-related or not. It's pretty much common sense. Like, if you were at work and, you know, more than one person gets sick and you haven't been around anyone else that's sick, you probably got it at work. So, but if you're conducting that investigation for purposes of deciding whether to report something to OSHA or not, I would recommend going to OSHA website and going through that list. And then again, employers need to remember that OSHA prohibits retaliation. So especially last year, and I think we're probably going to see some more of that as people start coming back to work, employees were complaining to OSHA saying my workplace is not safe. So if somebody complains and they make, let's say, a stupid complaint, like they're saying, their masks, or the masks don't work, or anyone needs to triple mask. And we all know under CDC guidance, those are sufficient measures. You still can't fire that employee for making the complaint. I'm talking about examples of employees that just keep nagging the employer saying, well, I believe, in my opinion, because I've read somewhere on Reddit that this doesn't work, or my Facebook, group talked about it and says vaccines don't work. You need to investigate the complaint. And if you conclude your safety measures are fine, that's okay. You don't need to, do anything else, but you certainly can't retaliate against the employee, no matter how silly their complaint is about safety. In 2020, there were, that's not right. It's not 1.5%, it's 15% more complaints under OSHA whistleblower. So in 2020, there were 15% more of complaints about safety than the previous year. So, and some of the examples of what employees complain about, and you can't retaliate against them, you can't fire them, you can't demote them, you can't treat them poorly because of their complaints. Some of those examples are, like in healthcare industry, a nurse alleged that she was terminated after raising concerns about the effectiveness of face masks provided by her employer. An assistant director of nursing alleged that, they didn't have enough COVID-19 training and she was terminated because of that, or they had inadequate staffing. A lab worker alleged that he expressed concerns about safety protocols and, he was, after he tested positive for COVID-19, and he was terminated because of that. So treat complaints about safety, again, no matter how silly they are, treat them seriously, and certainly make sure that there's no retaliation in against that employee. And then finally, employers should also remember that under the National Labor Relations Act, employees are allowed to engage in concerted activity which relates to the conditions of their employment. So if you have a bunch of people, let's say in a restaurant, that got together on Facebook and started talking about how they think that their workplace is not safe in a public forum, they really cannot be terminated for that activity as long as they're talking among each other and they're conferring with each other about what's going on in their workplace. That rule existed pre-COVID. It certainly applies to any sort of COVID-related complaints. So be aware that you can't really terminate someone for doing that, for exercising the right under the National Labor Relations Act. And I think a lot of employers obviously the kind of knee-jerk reaction is, you're talking bad about this place, you're out. But that you can't do that, because the consequence of terminating someone for exercising that right is you're going to be required to reinstate them and probably pay them some damages, aside from any bad publicity that might arise from the lawsuit. Let's talk about COVID-19 testing. May an employer administer a COVID-19 test or require one before permitting employees to enter the workplace? Yes. So, I know quite a few big companies that are actually doing that for any employees that choose to come back to the office right now. They have to get tested once a week. That does not apply to the antibody test. So that test cannot be administered by employers per the EEOC. They just don't consider that test to be necessary to determine whether somebody can come back to work. That might change. If it does, we'll have to update this. But for now, a regular COVID-19 test, okay to require. An antibody test, no. Vaccinations, hot topic, right? It was a hot topic 2 months or 3 months ago, whenever they first announced, that we have the vaccine. But it was very theoretical at that time, because vaccines were not available, nationwide, really, very limited amount of them. So it's really an employer that's going to roll out immediately a policy require everyone to get vaccinated will have to get rid of like 99% of their workforce. So it was all very theoretical, and all of the Wall Street Journal's articles that I was reading, talking, interviewing all the big companies about what they were going to do, no one really would come out and say whether they were going to require them or not. Or when. Even if they did say they were going to require them, they didn't say when. So, but as the vaccine, is becoming more available, some employers may decide that they want to require them. I would guess that the healthcare center might be, on the forefront of that. because they already require flu vaccines for all the healthcare workers. So it wouldn't be a far stretch from this requirement. So the general answer, can an employer require vaccination? Yes, with two exceptions. Again, disability, right? An employee says, I have a medical condition that if I get a vaccine, I'm going to die or have complications, or religion. And so for the purposes of disability, an employee, an employer needs to assess, does an employee have a significant risk of substantial harm to the health of safety to the individuals or others, in order for the employer to require for that employee to get vaccinated. They have to look, at the duration of risk, the nature of the severity of potential harm, and the different factors. So if that is met, if employee poses a significant risk to others, if they're unvaccinated, an employer can require vaccination in that regard. And then the employer has to decide whether to grant reasonable accommodation if an employee has a disability. And then the employer has to look at whether granting a reasonable accommodation would constitute undue hardship. Go through the interactive process again. So what would constitute disability for purposes of vaccination for COVID-19, as far as what we've seen so far? Well, life-threatening allergies. We've all seen articles about how some vaccines, I think we just saw that Johnson & Johnson had to shut down one of the vaccination places because 17 people had an adverse reaction to the vaccine. AstraZeneca has had many different kind of life-threatening, many, I mean, they've had publicized cases of having side effects with people that are prone to allergies. So if an employee says, I'm prone to allergies and it's documented, that could be disability. Diseases that compromise employees' immune systems, a severe and well-documented anxiety associated with vaccine side effects. So again, more than just, I don't like the idea of a vaccine, I don't think it works, that's not going to work. It has to be a medical condition. And then for purposes of the religion exception, it has to be, it's much broader than people think. It can be newly adopted. It could be like last week, I converted to this faith and it prohibits me from getting a vaccine. It can be inconsistently observed. So somebody doesn't need to go to church every week in order to prove that, their religion, that they sincerely hold the religious belief. They don't have to be part of a formal church. And they don't even have to have the same religious beliefs as the rest of the people that subscribe to that religion. And you'll see a very specific example in Texas of that. For example, even veganism may qualify as a religion. There's a court case out of Ohio where the court found that a person who believed that a vaccine that contained protein would violate their religion or their beliefs of veganism. So it's much broader than employers think typically. But last year in January of 2020, just a couple of months before the pandemic started, we actually had a very interesting case come out in Texas addressing this precise issue. Can an employer require an employee to vaccinate? And so quick, if you've been looking away from your computer, look back. I have a photo of a firefighter with a kitten, and a very important case to talk about. In this case, a firefighter in the city of Leander, who was also, so he was the truck driver and the pump operator, and he was also a Baptist minister. And the firefighting department issued a mandate that everyone who worked for the department had to get a certain vaccine, the Tdap vaccine. And so this particular employee, Mr. Horvath, said, I don't want to get it because my religious faith prohibits me. So the city did exactly what they're supposed to do. They came back to him and they said, okay, that's fine. We understand. So here are the two accommodations that we're ready to provide for you. One, you can transfer to a different department. You're not going to be driving the truck anymore, but you will be paid the same, benefits the same. So no, economic hardship arising from this. Or you can keep coming, to work and doing what you're doing now, but you have to get your temperature tested every day. You have to get medical examination every so often. and you have to wear a respirator the entire time you're at work. Well, Mr. Horvath said, I don't want to do either of those. He's like, how about I suggest this? I will only wear the respirator if I'm near a patient or something like that. And the city said, no, listen, here's the deadline. You need to come back to us and you got to tell us which of the 2 accommodations that we offered to you, you're going to pick. And he didn't do that. And so they terminated him for insubordination, for not getting the vaccine. And so, of course, he sued and he said, you know, you violated my religious rights under the First Amendment. You've discriminated against me on the grounds of my religion under Title VII, and you've retaliated against me by firing me. And the court in this case said, no, you're wrong. The employer did exactly what they were supposed to do. They gave you 2 options of how to accommodate your religious beliefs. One is wear the respirator, and another one transfer to a different department, which pays you the same salary. And you didn't want to do that. And I'm sorry, but you don't get to pick which accommodation you get. And so the court sided with the employer in that case. And that's a good example. You know, for COVID-19, what accommodations you can be offering employees if they don't want to get vaccinated, maybe wearing a respirator to work would work in that scenario. What about a flu? So somebody asked me before the presentation that question, what's going to happen during the flu season? And I mean, it's just the symptoms a lot of times are the same with the flu or with COVID. So I think it's, a couple of things that employers will need to be doing is, one, requiring employees that have any of those symptoms stay at home, and then also require them to get tested. So thankfully, by this time, we have testing available and they can pretty quickly determine if it's the flu or COVID-19 that they have. What are the consequences of getting this wrong, right? What are the consequences of somebody coming in and saying, listen, I just yesterday became a vegan and I think the vaccine has, protein in it and I don't want to get the vaccine because it's my religion. And you say, well, you're fired then. And I don't believe you have a religion. I don't think veganism is a religion. Well, you get a lawsuit on your hands, and the employee can, seek their lost wages. They can seek liquidated damages, which is on top of the lost wages. They can seek their attorney's fees. You end up spending time having people sit for depositions and gather documents responsive to the plaintiff's request for production, and spending time, dealing with the litigation and the stress of it. And so it's not pleasant. So it's much better to have a policy and train whoever it is in your HR department that's handling accommodation requests, on how to handle those, and have them prepared with what questions they need to be asking employees if they're claiming accommodation because they don't want to come back to work, to the office. All right, quickly on exposure at work. So typically when an employee gets injured at work, their injuries are covered by workers' comp. Exceptions, where the employer doesn't have a workers' comp insurance, they did something intentionally wrong or there's gross negligence. But for COVID-19 exposure, it's really, presumption is that employees are not covered by workers' compensation for that, because unless there's a provable link that they got it at work, the general kind of approach and presumption is that they were exposed to it somewhere else. So just an FYI. Now, if it's a job where the exposure to COVID-19 is higher than for the general population, then an employee may be covered by workers' comp if they can show that they contracted COVID-19 at work. So how to limit liability from all those COVID-19 related lawsuits? Well, education and documentation. Just generally 2 broad categories, subscribe to government agencies alerts, OSHA, EEOC, the Department of Labor, pretty much all of them have a service where you can go subscribe and you'll get a little email saying what the Department of Labor or OSHA just issued. So very, very good way to keep abreast of any new developments. If there are any local guidelines, follow them. Check guidelines and rules. I put weekly. It's aspirational. I know we all have a lot on our plates. That's why I think subscribing to the government agencies alerts is the best way to get the info. Document policies and dates. I mean, if you're implementing a new policy, have it in writing. You don't want to end up in court arguing with an employee who says they were singled out based on something, and you don't have a policy, right? You don't have a document that says, no, look, we required everyone to do this. So always have it in writing. Communicating with employees about what they're expected to do, what they will be required to do if they come back to the office, how often they will be required to do those things. Give them heads up so that they're aware, they're mentally prepared. You don't want to show up at the office and be asked to get vaccinated out of the blue. It's probably not going to draw a good reaction. Consult with a lawyer if you need to. If an issue arises, I think a lot of times talking to a lawyer is ahead of the problem, or when the problem was just detected, saves a lot of time and money than trying to handle it and then bringing that to the lawyer. But hey, we're happy to take whatever problems people have. Okay, and employers should always have employment practices liability insurance. It's not that expensive. It's a rider to the policy. It covers all kinds of employment claims, so that if you do get hit with an EOC charge based on a COVID or some other employment related issue, you can report it to your insurance company and they will take care of it. And then the last thing I want to talk about, and this is my last slide, you are going to have employees that are going to say, no way, I love working from home now. I have flexibility. I can spend time with my child and I'm not coming back to the office. And they will either agree to the new work requirements temporarily while they look for another job, or they will outright just quit. Okay. And so you need to be prepared that if somebody's not showing up for work, or they put in their resignation notice, or you sense that they're begrudged, that you are ready, that before they leave, you have their non-compete agreements, non-disclosure agreements, so that they're not taking companies' confidential information with them, they're not stealing customers, they're not deciding to run a competing company out of their, home office. You have severance agreement ready with the release of all employment claims in exchange for a certain sum of money, if you can afford to do that. Very wise to do most of the time. That you are ready to tell them what company property they need to return and when, and not just sit on that and then a month later remember that somebody had company laptop. That you're ready to shut down their access to company resources immediately upon their resignation or termination. And that you do an exit interview and try to figure out where they're going, and that you give them an exit letter. So they do have a non-compete or confidentiality agreement that you tell them in writing, either via mail or email, and tell them, listen, remember you have this agreement, you need to comply with it, you need to return company property, you have a non-compete, you have a confidentiality obligations, and just have that just like a clockwork. If you do have somebody leaving, that you have all of those steps, a checklist, so that you prevent any sort of leaks of confidential information, things like that. All right, I think that covers it.
All right, so now we're going to turn it over to Tabitha. Thank you so much, Leiza. That was incredibly informative. I know I've been speaking with some HR folks and also with my students, having discussions about what is possible for organizations to do to create the safest environment for employees. So that was really great information. And we have some questions in the chat. So Tabitha, if you want to go ahead and moderate those.
Sure.
Thank you.
Austin asks, do you think job sharing will become more common as many employees will stay home for longer periods?
I think that's an option. I don't know how widespread that will become, but I'm definitely seeing a move towards that. Yeah, and hot desks, so that people are free. There's a little more flexibility. So I think if an employer can implement that seamlessly, they will do it, especially if look, the employers are definitely looking, and I know there are articles going both ways, but the employers are definitely looking at whether they can save money by not making employees come back. In terms of real estate, especially, for Dallas, it's not an issue, but Boston, New York, San Francisco, where that office real estate is really expensive, if they can have somebody working remotely, they will do it. And so in that situation, yeah, job sharing could absolutely work.
Sharon asked, she said, what defines reasonable accommodations? And I think she's asking because she later explains that her issue has not been so much with what we are doing in their office, but what is happening in the common areas of the office building. So she can provide accommodations, but can't control what happens in the building, i.e. common restrooms. That has been the reason why some employees are refusing to come back.
Yeah, so a reasonable accommodation is actually a lot of times is the biggest issue in litigation. So I didn't want to get into it because going down the ADA it's getting into the weeds, but that is usually the question for the jury to decide, right? That's where the battle happens. If there's a lawsuit, the employer says, I offered X, and the employee says, X is not reasonable, I wanted Y, and you have a panel of, 12 people deciding what is reasonable. So it's an objective standard, but it's also somewhat subjective. In that particular situation, employees saying that they don't want to come in because, in that situation, if they have a medical condition where their exposure to COVID-19, for example, is going to cause them to have severe complications, more so than your regular person, then, and as part of performing their job in the office space, they have to use a common bathroom. Yeah, I think you would have to consider it the same way as if they thought that they would be catching it in the office. In other words, I don't see a difference in that situation between the common bathrooms and their actual desk, because they have to use both in order to work out of the office. So either hire someone that's going to clean the bathroom and pay out of pocket, which doesn't sound great. It's additional cost to the employer. Porta potty wouldn't work. You would have to think about what would work in that space. Is there an alternative? Maybe contacting tenants in the building and see if everyone will chip in to have a bathroom attendant. But if the cost of that is significant and it's undue hardship on the employer, then you don't have to do it. So but I don't think it makes a difference that the bathrooms are communal and you have no control over them, because I don't see an employee being able to work without using a bathroom all day.
The next question, that was very weird. The next question I see is if companies require testing, wearing masks or vaccines, are they going to be held accountable for any injuries caused by any of those requirements?
Well, I don't see anything. Let's say masks. I don't see any injuries being caused by masks, but testing and vaccines. Most of the employers will have employees sign a release saying that they're not really responsible. Hands off, I'm not liable for anything that happens in that case. So that's one way to handle it.
How can you actually prove the reason you decline the vaccine is due to religious beliefs?
So it sounds like a question from the standpoint of an employee.
Yeah, I think so.
Yeah. Well, look, I think it's just like disability. A lot of times for the employers, it's better to err on the side of assuming it is a disability or a religion and not fighting that as much unless it's completely unreasonable, but an employer can ask certain questions. I don't know if the burden is not on the employee to prove that it's religion, really. The burden is on the employer to prove that it's not, when at the end of the day, when it comes to court. And so I don't think the employee needs to provide, you can provide some educational materials about the religion, but at the end of the day, the question is it a sincerely held religious belief? And so how long have you held it? If you want to, disclose that information to the employer. But really, if it's a question of whether you want to keep your job, you would want to educate the employer on the religion somewhat. So maybe, suggest some materials to read.
Okay, I think maybe the last one we have time for is if employees do not believe in abortion and do not get vaccines with aborted fetal tissues, how do we respond? I think meaning, something other than disability or religion, or is that counted as a religion, or how does that work?
I don't think that that would count as a religion. It's a strongly held belief, for sure,
Yeah.
but I don't think it would count as a religion. Yeah.
Okay, Julie, turning it back over to you.
All right. Thank you guys so much, Tabitha, for moderating, and also Leiza for doing an awesome job of presenting a whole lot of information in a fairly short period of time. So we really appreciate it. Thank you so much to everybody for being here today. Like I said, we wish we could be face-to-face. Hopefully we'll have a chance to do that again in the fall or in the spring. Just a couple of closing statements. Tabitha, can you hit the next slide?
I'm gonna stop sharing. So it's back to you, Tabitha.
Oh, sorry. I guess I could have just asked for you to do it. In any case, I just wanted to say thank you so much again to Leiza for being here today. You know, providing all of that information. It's been really great. Like I said earlier, I've been having a lot of conversations with students and with some of the contacts that I have in the HR world, just trying to figure out like what is reasonable for organizations to do and to require in terms of getting employees back into the office. Thank you so much to Tabitha for moderating and for dealing with all the technological aspects of this and all of the other aspects of this that we have had to do with, like with this virtual transition in the past year. So thank you. We also want to thank John and Jennifer Kelly for their generous donations that makes these possible. And then also I would really like to thank Kathy Western, because she is the person who has organized all of these events in recent months, and we truly appreciate all of the detail that she puts into them, connecting with our speakers and getting them all of the information they need, getting me all the information I need. And so we couldn't have done this without her. So thank you to everyone, and we hope to see you again on September 9th for Dr. Yagi's talk, and we will send more information about what that topic will be as we get closer to that date. So I hope everyone has a great rest of your Thursday and a wonderful rest of the week. Thank you.